Good evening, ladies and gentlemen. My name is Olесь Lishevich, and I'm an intern at Standard Ocean Carriage. Today, I'm here to discuss a case involving large venue video and Standard Ocean Carriage. The topics to be addressed today are the following: carrier's liability for the damaged screens, interrelation of the bill of lading, the Carriage of Goods by Sea Act, and the concept of deviation. Review of the insurance policy and interpretation of whether Schuld is correct in its assertion that there is no coverage. Limitations and the specific relevant cover. Policy provisions that specify how a dispute with Schuld would be resolved. Firstly, the carrier's liability for the damaged screens will be assessed. The carrier receives the cargo, including the screens, in good order, without any exceptions made. However, the decision to stow the cargo above deck at the bow of the ship resulted in the screens being exposed to significant levels of salt air and water, causing damage to both their appearance and function. To determine the carrier's liability, we need to consider the interrelation of the bill of lading, the Carriage of Goods by Sea Act, and the concept of deviation. Regarding deviation, a deviation is a departure from the intended voyage or contract of carriage. It can occur either where voyage courses are specifically stated or not, but any departure from the customary route may be treated as a deviation. The term quasi-deviation signifies certain types of breach of a contract of carriage of goods by sea, similar to unreasonable geographic deviation, overcarriage, non-delivery, and delayed delivery of goods. Examples of quasi-deviations are the carriage of cargo on deck with an under-deck bill of lading, unauthorized transshipment, and dry docking with cargo on board. Section 4, subsection 4 of the Carriage of Goods by Sea Act states that any deviation undertaken to save life or property at sea, or any other reasonable deviation, shall not be deemed an infringement or breach of Carriage of Goods by Sea Act or the contract of carriage. However, if deviation is caused as a result of carrier placing goods on deck, while the bill of lading requires placing below the deck, the deviation, according to the established maritime insurance case law, would be considered unreasonable. Section 4, subsection 5 of Carriage and Goods by Sea Act, which provides that neither the carrier nor the ship shall in any event be or become liable for any loss or damage to or in connection with the transportation of goods in an amount exceeding $500 per package, unless the nature and value of such goods have been declared by the shipper before shipment and inserted in the bill of lading. Essentially limits the liability of carrier under specific circumstances. It is established by case law that where the deviation by the carrier was unreasonable, it would not be entitled to limitation liability provided for under the Carriage of Goods by Sea Act. Based on these rules, carrier can be fully liable under the Carriage of Goods by Sea Act if the deviation was unreasonable. In the present case, the carrier placed goods on deck while bill of lading requested for placement below deck. This constitutes unreasonable deviation. Therefore, even though the Carriage of Goods by Sea Act provides for potential limitation of liability, such limitation would not apply to standard ocean carriage, and it would be fully liable for damaged screens. Under the P&I Club rules, the trigger would be Article 5.1.1. The standard insurance shall cover the member's liability for cargo loss, shortage, damage, delay, or other responsibility occurring in relation to the carriage of cargo on the entered vessel. In other words, coverage would be triggered in case of cargo damage during the carriage of cargo, which standard ocean carriage satisfies because screens were damaged during their carriage by the carrier. Limitations. Under the P&I Club rules, Article 5.2.11, this article limits the coverage in certain situations, such as deviation or departure from the contractually agreed voyage or adventure which deprives the member of the right to rely on defenses or rights of limitations which would otherwise be available. In the present case, coverage could have been theoretically provided because damage indeed occurred to the goods of large venue video under Article 5.1.1. However, in the present case, coverage would be denied for standard ocean carriage on the basis of application of Rule 5.2.11. Specifically, standard ocean carriage deviated from the contractually agreed voyage. In according to Article 47.1 of the P&I rules, unless otherwise agreed, any dispute between the association and any member, co-assured affiliate, former member, or any party making a claim on the association shall be determined by arbitration in Oslo. To conclude, firstly, even though the Carriage of Goods by Sea Act provides for potential limitation of liability, such limitation would not apply to standard ocean carriage. Secondly, in the present case, coverage would be denied for standard ocean carriage on the basis of application of Rule 5.2.11, specifically standard ocean carriage deviated from the contractually agreed voyage. Thirdly, the disputes between carrier and Skald are to be resolved by arbitration in Oslo. Thank you for your attention.